Brilliant, that's the noise.
No.
Brilliant, thank you. And we will kick things off with Mikey, who's going to be talking about various things to do with all about utilising your rights as private renters and disabled people.
Thank you so much, and so great to see so many people online for this. Hopefully, super useful session for everyone. As a bit of context, I'm Mikey. I'm a campaigner here at Disability Rights UK. We are a national DPO, Disabled People's Organisation, which means we're run by and for disabled people. I work predominantly on housing and social care. Today is going to be a bit of a whistle stop. I have a presentation and I have more detailed notes that I'm sort of reading from as a script, which I can always share with people, or bits I can share with people afterwards. We're covering a lot of topics. It's not a lot of time. It's not an extensive deep dive. This is sort of an overview as best as I can on a couple of topics, including benefits and universal credit, on adaptations, and on disrepair, three of the sort of most common things that people speak to me about. The PowerPoint is pretty straightforward. None of the images are vital. They're all decorative, but I will give a little description in lieu of being able to share alt text for anyone who sort of doesn't, who requires that sort of thing. So on this slide, it's just 4 people sort of protesting. They're holding up a sort of loudhailer and it says "Fight for your right." That's the sort of description I can give. There isn't much else on the slides other than text, but just for anyone who might not be able to see them or is visually impaired or just requires sort of a description of anything on the slides, that's for you. So cool. It's going to be quite speedy. I tend to talk quite quickly. If you need anything repeated, feel free to sort of pop a question in the chat. Won't be able to get to all questions probably later on. And if you have dense technical questions, please sort of get my email from Tilly or anyone else putting it together, and I'm happy to help you in that regard. But probably today, given just the time constraints, be a bit easier to have sort of straightforward sort of thoughts and questions, but no pressure. Anyway, so that's me, a bit of an overview of what we'll do. So it's going to be social security, disrepair, and adaptations. So first topic is benefits and universal credit. This is probably the main thing that people come to us at Disability Rights UK to ask about, because as a lot of you will know, our social security system is incredibly confusing. It's really, really dense, and it's not very straightforward at all. I think the sort of key things to sort of remember is that housing benefit is mainly meant to help you with rent, but also some other housing costs. A lot of disabled people, in particularly older disabled people, will still be using and navigating the existing housing benefit system. I'm not going to go into too much detail about lots of the specifics of housing benefit, mostly because over the last 5, almost 10 years actually, universal credit has been introduced, and universal credit is what most people of working age will use now to cover housing costs, or be offered by the government to cover housing costs. You aren't really, unless there are some very specific circumstances, able to make a new claim for housing benefit. Instead, you make claims through the universal credit system to cover those costs. That's just sort of something to be aware of. If you are at the moment in receipt of housing benefit, that's like to be expected. You might be moving away from that and be moved on to universal credit in the future. But for most people, they will find their basic living expenses, which encompasses housing costs, covered through the universal credit system in some way. That's sort of where to start. The point of universal credit is to cover housing costs and to cover rent, right? It's meant to meet your basic living expenses. It is a means tested benefit, and it doesn't depend on your national insurance contribution, and it's not taxable, but it is means tested, and how much money you have coming in does affect how much money you get via universal credit. So if you pay rent, an amount can be included in your universal credit award to help cover your rent. It's unlikely, and especially as rents continue to rise, that universal credit will cover all of your rent, but you do get a certain amount up to a certain threshold. It depends sort of on a lot of factors that, if I went into all of them, it would be very exhausting and boring for you all, but sort of important to remember there are certain very specific reductions that can happen. One of these is if your home has more bedrooms than you may need, or the government defines as being needed, you might see your amount deducted. It might also be reduced if you have other adults other than your partner staying with you. Quite often, we see people challenge things around both bedrooms and also on sort of who's staying with them. But that requires like specific advice, which isn't sort of easy to do in this sort of setting because it's very tailored to the certain sort of situation that you are in. Cool. So as I've just said, your housing cost is worked out at a sort of rough level, and then is the DWP, the Department of Work and Pensions, will deduct certain costs based on lots of things, including your bedroom. You might be asking, how many bedrooms do you need, or how many bedrooms does the DWP take into account? So when they are calculating your housing costs, the DWP decide how many bedrooms your household is considered to need, taking into account the number of people in your household. If there are disabled people, right, who might require different facilities, the ages of family members or what are called dependents, and you're essentially allowed one bedroom for each of the following people. So that is you and your partner, unless it is inappropriate for you to share because perhaps your partner is disabled, requires more space or something else. A qualifying young person or your partner are responsible for a qualifying young person. And a qualifying young person is a non-dependent age 16 or over, 2 children under 10, and again, unless it's inappropriate for them to share a bedroom because of disability or impairment, 2 children under 16 of the same sex who should not, and this is how the government defines it, unless it's inappropriate for them to share a bedroom because of disability, and any other child under 16. If that is confusing, yes, it is confusing. A lot of people come to us because the bedroom sort of allowances and how it is deducted based on space is very difficult, and quite a lot of people have to challenge it. And there's a lot of sort of case law in this area, a lot of things to consider. But in general, what you just need to be thinking about in regards to universal credit is that it's not just about the cost of your rent. It is also about the space that you have and how you are using it. That is how the DWP are calculating what they allocate you. So if you have a disabled child who is not reasonably able to share a bedroom, you are allowed an additional bedroom for them. That child, though, must also be entitled to certain other components of things such as disability living allowance or other benefits, right? So they also need to have been assessed as disabled by the DWP. It's not something that you sort of just self-report. The sort of last important thing to keep in mind in this area, and like I said, it's very, very technical, it's very confusing. Even as I'm saying it now, I'm getting confused, is that like there is lots of help and support out there for you to navigate this. We at Disability Rights UK even have like a free handbook on universal credit that you can sort of pick up at any time. That is much more detailed than that I'm giving to you now. But you just do need to be considering when you're making claims, both what is my rent, what is my financial situation, but also how am I using my house and my space when you're sort of declaring this for it. So you are also allowed an additional bedroom for a carer or carers to sleep in if you, your partner, your child, which includes a foster or adopted child, or an adult non-dependent need overnight care, and you get one of those sort of benefits that I've listed before. These carers or carer must not be living with you, but must be engaged in providing overnight care. So that sort of bedroom allowance there, if you had extra space for someone to stay, has to be because they're providing overnight care and must be staying with you on a sort of regular basis. Even if you have more than one carer, unfortunately, the way the system is built is that you are only afforded one extra bedroom. There are slightly different rules in Scotland and also slightly different rules around quite a lot of this in Wales, but we won't dive into those right now. So there is something that exists called discretionary housing payments. And they are the sort of payments that exist if universal credit doesn't cover all of your housing costs and your local authority has sort of deemed that you need some further financial help. You must claim it from your local authority. This isn't something that you can claim nationally. It's something that you have to go to your local authority to claim. So local housing allowance is one of these additional discretionary payments. And it applies to your case if you are unable to cover all of your housing costs. quite often the local authority will decide that it needs to step in, and that it's a sort of standard amount of maximum housing benefit, which is set according to where you live and how much it costs where you live. So it does vary depending on where you are. It applies if you're renting from a private landlord and you have moved or started a claim for housing benefit from 2008. So it's been around for a long time. Local housing allowance, there are still people who don't get it because they started to claim before that, but local housing allowance is quite an important one. One thing to be really wary of and understand is that if your local housing allowance is still less than rent, you are expected by the government and by your local authority to make up that shortfall, right? If even with a discretionary payment, you can't meet the full cost of your rent, you are meant to find a way to achieve that or seek cheaper accommodation. It's a reason why organisations like Disability Rights UK, places like Shelter, and other large homelessness charities have campaigned for local housing allowance to go up, because local housing allowance across the country is very unlikely to cover what is needed. The way it is calculated and why it's pretty ineffective is that the broad rental market area is what's used to define how much money you get. And that is the area which you could be reasonably expected to live within, having regard for the facilities and services that you might need and the range of accommodation and tenancy types you would require as a disabled person claiming benefit, right? So it is very confusing. The benefit system is really nebulous and difficult to navigate. I would always recommend that if you are either starting out trying to make a new claim, trying to understand the system better, the best thing you can do is sort of visit either the Shelter website, Disability Rights UK's website, and get sort of a base level understanding before you start doing anything else. I think you should also always be aware that there are helplines that can support you. I have just clicked out of my PowerPoint, fantastic. There are a lot of resources that exist that you can visit. And the best thing you can do is not rush yourself. It's not something that you should put yourself under a huge amount of pressure to do, because there is advice out there. Great. That's where we're at with sort of the broad overview. There are still lots of things available to you as a disabled person with regards to the benefit system. Unfortunately, I would need like a good couple of hours to walk you through it in depth. And I don't want to, one, bore you, and also make you all feel quite down on this Tuesday. So we're going to leave it there for benefits. If there are specific questions, I'll try and approach them and answer them later on, or via email or further correspondence. Sorry for that super confusing whistle stop tour. I tried to make it as easy as possible. It's just really, really hard. So on to the next one, which is probably, if not benefits that people come to me for help, it is help with disrepair. And so we've now moved on to a new slide design, by the way, for people. It is a small icon of a house that is also kind of a hammer to designate disrepair and repair. So disrepair is defined as something working in your home that is not working as it should. It's pretty intuitive in your mind of what disrepair broadly is understood as. So disrepair is one of the biggest problems that people come to me at Disability Rights UK to sort of ask about. Kind of examples of these sort of things that are quite common are broken windows or boilers breaking down, or quite often common parts issues if people live in blocks of flats, or with others, which is like issues with lifts. I will talk about lifts a tiny bit later, because there is quite a lot of issues around getting repairs for these sort of common parts that a lot of disabled people are still campaigning on to get changed. So when disrepair occurs, there are lots of different things to keep in mind, but there is a set of rules out there that all landlords, all private landlords, have to follow, and those are the housing health and ratings, the housing health and rating system. It is a bit of jargon, but it is a good overview that if you ever trying to figure out whether or not something that has happened in your home is something that the landlord has to deal with, that should be your sort of overall first port of call. It's quite a dense thing. I'm not going to go through all of the things that are in there, but you should remember that based on that system and the things within it, landlords have a legal obligation to keep your house that you live in safe condition and make sure it's good enough for you to live in, right? And that's what the point of this sort of rating system is. So the sort of stuff that is usually defined as a landlord having a sort of statutory duty or legally be required to maintain are things like the main structure of your home, walls, windows, roof, guttering, doors and drains, the supply of gas and water, so that includes hot water, but also electrical wiring, working radiators, fitted heaters, boilers, yearly gas checks. Then there's also basins, sinks, baths, and toilets. Common parts of the building, such as lifts and stairwells, but this is slightly more complicated, and I'll cover in a bit. You are meant to sort of have your landlord keep you free from mold, but again, we know that this is something that a lot of landlords sort of weasel their way out of, and is a little bit more complicated than just if there's mold in your home, your landlord is going to fix it adequately or anything like that. It's a little more complicated, unfortunately, which makes me incredibly angry, but I'll spare you all that for now. They're meant to maintain smoke alarms, carbon monoxide detectors on every floor of the home. If they've provided you any electrical appliances when you moved in, so your fridge or an oven or whatever it is, if they've provided it and it's on your itinerary when you move in, they are responsible for that. If it is something you've bought yourself, then unfortunately not. And sometimes in tenancy agreements, and it's why it's always really, really important to read these thoroughly. One, because landlords try and sneak things in, but landlords might also have committed to extra responsibilities. If they have got, like, you've moved in somewhere and it's got loads of electrical appliances the landlord has provided, they might have written into their agreement that they are also responsible for those. You as a tenant do have some responsibilities yourself, and those are keeping the home reasonably clean, making sure that any appliances you've brought in, I don't know, if you've plugged in 800 extension cords to fire, I don't know what, and that shorts the electricity, that's your responsibility, right? Any electrical appliances that you've brought in, it's your responsibility to keep them safe. If you have a garden or a balcony or any sort of shared outside space, it's quite often your responsibility to keep that in a reasonable state. And then this is the damp and mold element, is you are meant legally to keep the home ventilated. And often we'll see landlords argue that it's been tenant failure. I don't know, you've not been opening the windows even though it's -5 outside or raining. And that's why you've got mold. It's not a structural issue with the home. Those are sort of the general obligations. But the big, big problem with disrepair is the thing that you can see on this slide, which is a landlord is not really held to any legal standard for good repairs, right? So the standard of repair can depend on the age, character, and prospective lifespan of your house, right? The property doesn't have to be repaired into a perfect state. It really is on a landlord to sort of define how good a repair is. It can be very difficult sometimes, because you might have something in your home that breaks. Give a good for instance for this. So I have a lift that breaks every month or so. My partner, my best friend, and I think 2 post people in the last year have gotten stuck in this broken lift, right? It breaks, people get trapped, but the landlord will always repair it, right? They will always repair the lift. It will get working again for about a month and then it will break down again. That at the moment is legally, it's in a gray area, I would say, but it's on the landlord sort of in their like side. It's very difficult to challenge that sort of thing. So they don't have to replace something like for like. I don't know, they provided you with a fantastic fridge. It's super modern, very beautiful, and then it breaks. They don't have to replace it like for like. They can get you anything from the big landlord store of the oldest appliances you've ever met. So long as it is still the thing that was on the itinerary, then it's okay for them to replace. But there are some sort of general tips that I would advise anyone to do when you're interacting on disrepair, and a couple of things to keep in mind. So the first thing to understand is that your landlord is very, very unlikely to be able to charge you for any repairs that breach the contract that they make. So if there's something structurally wrong with your home and you think it's your landlord's obligation to repair it, if they come and repair it, it is highly unlikely that they should be able to charge you for that. It's something that you should seek advice on if they are saying, you know, you've said this window has been broken for months or the hot water's been out for months, and then the landlord repairs it and then tries to charge you for that. They don't have a legal basis to do that, and you should challenge that. But I know it's very easy for me as the person delivering a presentation to tell you to do that, but it's just something to keep in mind, right? General tips on disrepair are keep all written records as possible, as many letters or emails asking for disrepair. If something is really affecting your health, I know for a lot of disabled people I speak to, it's the health impact of disrepair that is so frustrating. Keep a record, if you talk to your GP, ask them to sort of provide you with a doctor's note if the disrepair has impacted your health. Record any sort of text or phone interactions with your landlords. And what I'd personally say, and this is sort of in a personal capacity, avoid talking to your landlord about disrepair over the phone. You want them to get into written commitments because, as we all know, they will try and find ways out of repairing things or making changes. And what they say to you on the phone is very easy for them to just say, oh, I didn't say that, or ignore it or pretend it didn't happen. Try and get things in writing. When you move in, take photos of everything, save it in a folder somewhere on your phone, on your computer, wherever. Take photos of everything so that you can claim against or dispute any damage as goes on, right? You do have a right to live in your home. You have a right to enjoy it. You shouldn't feel like at any minute your landlord is going to say that you've broken something. So just make sure you take photographs, get copies of any complaints procedures or repairs policies that your landlord might have. And I think the last bit that is really important is, one, go to trainings like this, learn a lot more, empower yourself through your rights. Quite often, landlords, letting agents, they're just trying to see what they can get away with. And I've had it in my personal experience where being able to quote the law back or being able to quote their own policy back has been helpful. But that isn't obviously the be all and end all, but that's just a little bit of extra advice on that. There are lots and lots of things that are other than what I've already mentioned that a landlord is legally required to repair. And in the notes that I can share later, there is sort of more of a breakdown of that. Cool. So the last bit of this whistle stop tour is adaptations. So adaptations are changes that a landlord might make or you might make to your home that allow you to navigate it as a disabled person more effectively without as much support needed. And there are a couple of ways that you can sort of get help and support with that. We also have a couple of template letters I can sort of share with you and ideas on how you talk to your landlord about it, because in particular, getting adaptations to your home as a private renter, despite them being so useful and so important, is really, really hard, right? The percentages really show that people who live in social housing are much more likely to get adaptations, and there's lots of reasons for that I won't get into, but this is a really, really important thing. So the sort of like rough ideas on what adaptations are things like ramps to make it easier to get in and out of your home. For a lot of people, they come to me because they might want a shower rail or like a grab rail in their shower because it's difficult for them to get in and out of a shower or tall bath or that sort of thing. There is a threshold by which your landlord should be making those changes if you ask for them, but it's quite often that even these really minor changes are very, very difficult to get. But there are grants and support available from your local authority, which should help you meet the cost. So that's something that we'll dive into in a little bit, which is Disabled Facilities Grant, which is the main grant for that. The one thing I wanted to make clear is that, like, to get adaptations, you do need your landlord's approval. That can be difficult to get, and we know that for a lot of people, landlord refusal, which is very heavily like weighted onto the landlord's side, can really like prevent you from being able to get the adaptations that you need. And there is frustratingly not a huge amount that you can do as an individual to push back on that. But what you can do is go to local authority, demand it. You can do a lot of sort of pressure-based work, but it isn't something where the law is necessarily on your side. But there is going to be a bit more of a conversation about the law and this stuff happening later, which should be helpful. But when it specifically comes to adaptations, we know that there's the law and then there's how a landlord behaves. So there's just that to keep in mind for yourselves as well. So let me just move that away. You might also be able to get help with adaptations as part of any care and support package that is provided by your local social care department if you're in receipt of social care. This does also make navigating the system quite confusing because you might be getting money or support not necessarily from sort of the housing part of your local authority, but actually from the social care part of your local authority. And that can be difficult to manage. But lots of local disabled people's organizations are very well equipped to help in these scenarios and have the sort of local expertise around who will be doing what and how they be doing it. Cool. Now there we go. So what are the sort of things you can get adaptations or a grant for? You can get them to have easier access, like I said, a ramp or something like that, to make your house safe for you. And that really is defined as something specially adapted. So you might need a specially adapted room, maybe a wet room, or if you have specific impairments that might mean you need more of a safer space to be in, where you could be left a person could be left unattended, or providing improved lighting for someone with a sight problem, right? Like making your home safer. And I think important to understand, safer than the average very inaccessible home is the way to think about this. Making your home safer is something that you can sort of get support with. Easier access to living rooms, or quite often it's bedrooms, or easier access to washing facilities, lavatory, bath, or shower. We quite commonly hear that access is one of the things that is most commonly provided, if that makes sense. But that doesn't mean that access is the be all and end all that you should be thinking of if you need an adaptation. It's just something that local authorities are most used to providing, or most comfortable with providing. But you do also have the ability to request improved heating systems, different sources of power, light and heat, or having easier access to other bits of the house like gardens or sort of your driveway, those sort of things are also available. But it's not just access, there are other changes to make your home safe that you can get help with. So the main way you can get additional financial support, and that's what DFG is. If you can't pay for this adaptation, if it's so substantial that you aren't able to afford it yourself, is Disabled Facilities Grant. So that it goes about a maximum of around £30,000, but actually there are sort of two things that this depends on, which is one, the amount of money that you get and the savings you have. It is quite, although it's not meant to be, it is quite often means tested, and sort of is quite what I would define as quite harshly means tested. So the amount of money you can get, it varies quite significantly. It varies from local authority to local authority based on their own budgets and their own processes. Local authorities are also across the country top this amount of money up using what is called discretionary funds. So similar to what we mentioned earlier on benefits around having discretionary housing payments. This is another area where a local authority could provide you extra money if they deem fit, but that is something that really happens on an individual sort of case basis and isn't something you're guaranteed. It really depends on your local authority. So those are sort of two things to get in mind. The headline figure here is that you could get up to £30,000, but being very honest as well around like the experiences that we hear from disabled people, that money does not go as far as you think it would, right? Costs for building, costs for doing anything really have risen over the last sort of 5-10 years, and that £30,000 quite often doesn't go far enough. And so we're, as an organization, seeking to have that sort of improved, but that's for another day. So to improve your application, the local authority has to meet two tests, and these are quite difficult and again, quite nebulous. So the first thing is that they have to be satisfied that whatever you're requesting is necessary and appropriate for your needs as they've been assessed, right? So if you're asking for a ramp to get into your back garden, for instance, they have to, as a local authority, be satisfied that that work will, one, achieve that goal that you have, and also is appropriate for you and your impairment. And that means there is sort of an assessment done by an occupational therapist who will come in and sort of assess whether or not this is the right thing for you. And then the other element is that it's reasonable and practicable in relation to the property. And this is quite a stickler quite often. So we see sometimes that perhaps a wheelchair user might require a lift, but the property or the flat they live in is on the second floor of an old, let's say, townhouse, right? The local authority will look at that and say there is no way that we can reasonably, and I'm putting that in speech mark because that is not my personal opinion, something that is too important, but they will say reasonably, we're not able to do that to this property, so we can't give you money, right? It is also an assessment of whether or not the change made is going to be done easily, practical. Is it going to take years of work to make that change? That's something that they assess at the time. Great, cool. So the last thing that I really want to make clear on adaptations is that if you get a Disabled Facilities Grant, it is mandatory, right? Like if you meet the conditions as set out by the local authority, you should get a Disabled Facilities Grant. But to approve it, the local authority has to make like these decisions. And the last thing that they also check, and quite often it's the first thing that they check, is whether or not your landlord is happy with it, right? And we know that landlord refusal in the private rented sector is a big issue. Your landlord does have to be sort of satisfied or approve of the works being done. And a lot of landlords, unfortunately, don't really understand our needs as disabled renters, and they quite often refuse or are confused or think that, you know, this work is going to somehow damage the property, and a bit, I don't know what the right word to use is, perhaps apprehensive about making significant changes. So you do need to be sure that your landlord is satisfied. And sometimes you can do everything right and your landlord is still not, you know, willing to do it. The last thing that catches people out quite often with Disabled Facilities Grant is the sort of myth around having to say that you're going to live somewhere for 5 years. So in the sort of forms that you do when you apply, you are asked to sort of confirm that, you know, if this grant was made, that you would want to live in the property for around 5 years. Landlords quite often don't like that because, you know, having someone in situ for that long might affect their ability to make money. And you might think, I don't want to live here for 5 years, so I'm not going to say yes. It's not saying you promise that you will live there for 5 years. You're just saying that, you know, if this change is made, you would be able to live there for 5 years. That's sort of the distinction to do. And that's sort of just important to keep in mind. It's not you signing 5 years of your life away. It is a bit more technical than that. Cool. That is everything that I have. It is a super whistle stop tour. And I think what I want to leave you all sort of on, one is sorry that I've missed loads of bits. Sorry that it's been me talking super quickly, but then also that the law and legal advice is one thing, and there is lots of support and legal advice available. We're going to hear more about the law in a second. There are places like Citizens Advice or community advocacy from your local DPO. They can often help, right? So I live in Tower Hamlets. I have a local DPO called Real. They are great. They can provide lots of advocacy for disabled people in similar situations, but capacity is tight. And what I really want to make clear is that in a lot of housing stuff, the law isn't always on our side, or the law is vague enough that it is quite difficult to push for it. So there are two other sort of broad groups that can help you, and that is campaigning organizations locally to you. So that is housing campaigners, things like E15 in Newham, right? Anti-gentrification organizations, people who come together to campaign specifically locally on housing issues. They might be able to get you support or advocate for you or put pressure on a local politician to sort of take up your case as a matter of urgency. And then the last one is community tenants unions. So in London, that will be London Renters Union. Across the country, that is places like Acorn, Greater Manchester Tenants Union, Living Rent in Scotland. These sort of community tenants unions can quite often do two bits, which is provide you with the support and advocacy that you might need to understand your situation, but also help you build the power that you need as a disabled person to enact your rights by coming together with others. There we go. That's sort of my bit of the presentation. I hope it was helpful. I can see a few questions in the chat. I will try and get to them. And if I can't do it in the Q&A at the end, I'll also just try and type things in the chat and be helpful. Alrighty, thank you so much, everybody. And over to Rose next.
Brilliant. Thank you so much, Mikey. Yeah, obviously a lot of information there, and hopefully, yeah, there's obviously a lot more out there, but this is, as you say, the stop tool, so I'm sure people find it very helpful. Amazing. So Rose is next from Shelter. I will be sharing Rose's, well, not Rose's, I'll be showing Rose's presentation. I'll be showing my screen. So I won't be able to see what's going on with the chat and stuff, so I might be a bit slow, but Bisma is also on, so I'm sure she'll be able to flag stuff as well as the other panelists. So let's go for it. Brilliant. Yeah, great. So Rose, take it away.
Thank you. Hello, everyone. My name is Rose. I work for Shelter. I have worked there for about 12 years now, and I'm now a lawyer in our strategic litigation team. I led the work on our DSS discrimination campaign, which I'm hoping most people will have heard of, but basically trying to demonstrate that landlords who have blanket bans on renting to people in receipt of benefits were carrying out an unlawful discriminatory practice, because you are more likely to be a woman or have a disability and be reliant on benefits. So I'm just going to quickly talk about kind of the legal and evidence bits that we had to do to get to those cases, and have a little think about other cases that we might want to look at. So in England, it's the Equality Act 2010 that makes discrimination unlawful, although despite it being 14 years later, I don't know if many landlords are aware of what it means. There are two types of unlawful discrimination. Direct discrimination, I think, is kind of what anyone thinks about, which is when you are treated less favourably compared to others based on your age, your race, your gender, and it's quite easy to spot. So as I put in the example there, if a hotel turns someone away because they are gay or because they are black or because they're a woman. So it's quite easy to spot and it can't be justified. Indirect discrimination is when there's a practice or a policy which can actually just be a one-off decision. It doesn't need to be something that's written down. It can be quite informal, where it looks like everyone's being treated the same way. And by everyone, I mean everyone that doesn't fall into a protected characteristic group. So that's age, race, gender, etc. But in fact, certain groups of people are disadvantaged by that, perhaps accidentally, without it being known, or unknowingly. And so I've given an example there of a shop that gives everyone a new shift pattern, says everyone has to work the same number of Saturdays, and it seems like that's fair, that's what everyone's being treated the same way, but actually there are people who, because of their protected characteristic of religion requires them to abstain from work on Saturdays, will be particularly disadvantaged. And the DSS cases were an example of indirect discrimination, and this is what you have to prove. So I'm just showing a slide with some of the elements of what you have to prove to be successful in bringing a claim for discrimination under the Equality Act. And that's that there is a policy that's applied to everyone, that it disadvantages people with your protected characteristics. So one of the disadvantages of the Equality Act is that you have to be a victim of the discrimination yourself, and you have to belong to the protected characteristic group. So you have to be the disabled person that has been affected. You have been disadvantaged personally by this practice. And then the organisation or landlord has the opportunity to show objective justification. Now, my experience is that most landlords or estate agents don't even know that their practices are disadvantaging disabled people in an indirect way. They're not even aware of it. They haven't done the research, or they certainly haven't listened to people who have said it to them. When we first started the DSS cases, I would write to landlords and agents and say, did you know that this practice disadvantages disabled people? And I'd get responses going, but I'm not racist, I'm not sexist, I'm not ableist, how could it possibly? People don't like being called those things, and I think they struggle then to kind of see past that. Actually, the point of this part of the law is that it's addressing unintended consequences, unconscious bias and impacts of practices. But anyway, the law allows an organisation to objectively justify indirect discrimination. And like I said, from my experience, they rarely can, but there may be examples where they can show a good reason for having a particular policy. The only one I can really think of is, an example where you might want to have single-sex spaces or child-only spaces, or you might only want to hire certain groups of people for certain jobs. So like I said, DSS discrimination is an example of indirect discrimination, and in practice we did research to show that it disadvantages women, disabled people and certain racialized minorities because their income is more likely to include benefits than others. In order to bring a case for discrimination for someone in receipt of benefits, you have to obviously get legal aid, and that's really tricky because you can either get legal aid by showing that an issue is of significant wider public importance, or you have to show that you have to meet a cost benefit ratio, which is basically impossible because of how low the damages are for Equality Act claims. So we knew we had to show that this was an issue of significant wider public importance. And we did that through a series of surveys of landlords and private renters and our service users, and then kind of extrapolating out from that to show how big of a problem DSS discrimination was. And then we had to show, again, through, Shelter's really lucky, and I know that most people who are affected by discrimination can't just email their research team and say, hey, I think I'm being discriminated against. Can you check that this is the case, that the people with my protected characteristic are being disadvantaged? And we're always willing to help wherever we can with our research for cases like this. So we were able to show that you're more likely to be in receipt of benefits as a woman, disabled person, a Bangladeshi family, or a Black family. And then we had to preempt what possible objective justification a landlord or agent might use. And we did that through a series of landlord surveys, asking landlords, why are they refusing to let to people in receipt of benefits? And they came back with these 4 reasons, which were they thought there was going to be a risk to their income, their mortgage wouldn't allow them to, their insurance policy wouldn't allow them to, or their letting agent advised them not to let to people in receipt of benefits. So we kind of went about, as our first stage of, after doing that initial research, so maybe our second stage of our campaign was to try to address all of those potential objective justifications and kind of like bat them out of the way before we brought our legal cases. So we researched what the actual risk to income was to landlords renting to people in receipt of benefits. And probably unsurprisingly, it's frustrating to have to do this kind of research, but people in receipt of benefits actually are very good at budgeting, have to be very good at budgeting, prioritize their rent, and often stay in homes longer than others. So there's not a risk to income that is significant. And mortgages, there were a lot of mortgages with these restrictive terms in, but none of the mortgage companies knew why or couldn't justify it. And we worked with an amazing landlord who was told to evict her tenant because she was in receipt of benefits by her mortgage company. And she was like, no, she's been there for 5 years. She's an amazing tenant. I'm not going to do that. And she helped, and she was happy to publicize her case and helped us to initially persuade NatWest and then all of the other mortgage lenders to scrap their restrictive terms. And I think now it's over 99% of the buy-to-let mortgage market has no restrictions on it. And in any event, only 48% of landlords have mortgages. And a useful little trick was to look up on the land registry, which costs you £3, whether or not your rented property, whether your landlord has a mortgage. And most of them don't. So when they say, oh, I can't my mortgage, you then show them the land registry and go, really? Because you haven't to the land registry if you do. Or it would give you a name of a lender that we knew for certain didn't have that term. So we had the first case was Emma's, where this was the first case we started to pursue to court, where the agents had refused her, saying that, oh, it's the mortgage, we can't rent you this property because the landlord's mortgage says we can't rent to people on benefits. The agent had never checked the mortgage, didn't have a copy of any policy or term to show that it was restrictive. It's settled before court, as lots of good cases do. And they committed to retraining their staff and changing their policies and paying some compensation and costs. One of the other potential objective justifications was, oh, my insurance policy won't let me, which is just really interesting when you look at the power dynamics of, no landlord has to have insurance. I think they all should. I think, they're running a business and they should insure the risks of that. And we worked closely with the British Insurance Brokers Association and lots of insurance providers who said, of course you can get insurance to rent to people in receipt of benefits. You can get insurance for anything. You just have to choose the right one. And having an insurance policy doesn't stop you doing anything. Like if you accidentally get the wrong travel insurance, you only get it to cover you to go to France, and then you actually go to America. No one's stopping you going to America. You just can't make a claim on it. Anyway, it's a ridiculous reason, but we tried to really get into the detail of every potential reason to show how ridiculous it was, and worked really closely with certain members of the industry and to show that, yes, you can get any insurance. And in fact, you should always get insurance as a landlord to rent to people in receipt of benefits, because whoever you rent to may well at some point in their life need to claim benefits during the course of their tenancy. Anyway, so again, did a case specifically on that issue. The agent had refused, saying that the landlord didn't have insurance that would cover it. And that case, again, settled before court in favour of the tenant. And then
Sorry, just to
other,
quickly flag,
yes, go for it.
we are a bit short on time.
Oh, yeah,
So it'll be good to get some Q&A just as well. So I appreciate that's not your fault or anyone's fault, but just to sort of mention. So
yeah, got it. Yeah, we really don't have long, do we? Okay. Anyway, suffice to say that we went through all of the potential objective justifications, did our research, then took a case against it to try to then ultimately get to the place where you could not have any justification for this type of discrimination. And that's the kind of, and I've put a little extract from some of the cases that did go to trial, the level of detail of our evidence and research that we had to put into it in order to be sure that we were successful. Once we've done all of that, we're now trying to embed actual change in practice, which is really difficult. We've got a load of template letters to make it easier for people to complain about this kind of practice. We try to run trainings for landlords and agents, renters, advisors, local authorities. Reflections on our impact is that although we had 10 successful court cases, and there has been a change in practice, it's not been as significant as we would want it to be, because it's really difficult for tenants to continue to hold landlords to account. Even though landlords know that it's illegal, even though the government has promised to make it directly and more clearly illegal, it still continues. So there's still work to do. And there are a couple of videos that I would recommend watching at some point that we've produced to look at other types of income discrimination. So it's not a landlord saying that you are discriminating, that you can't rent because you're in receipt of benefits, but it's saying you have to earn a certain amount, or you have to have a home owning guarantor, or you have to have this amount of months rent in advance, which we know certain groups of people are never going to be able to achieve. And so it is indirect discrimination as well. And I've put a link here to some others' work where they've got some really useful practical things, like our practical kind of templates on how to complain. There's this excellent guide on how to bring your own discrimination claim by Doug Paulley. There's the Disability Justice Project. Again, they have loads of template letters. The Equality Advisory Support Service, you can call them and they can give you advice about the Equality Act and your rights kind of there on the phone, but they also have template letters. And there's just a list there of some other free legal advice and representation service for discrimination claims. There we go, that's me.
brilliant, thank you. Sorry, I was not moving the presentation whilst that was happening, so wasn't
It's
where I was
okay.
supposed to be.
You can send it round to people.
Yeah, sure, I will do that. Amazing, thank you. Brilliant. Well, thank you so much, Rose. That was excellent. I'll very quickly just sort of say we're a bit short on time. We'll go immediately to the Q&A now. I will have a read out. I think Mike has been very helpfully answering a number of the questions. I'm just trying to keep track of where we are now with things. I was going to start reading the Q&A, but they've all been answered very helpful by Mikey, so thank you for that. So looking in the chat, someone has asked if you were claiming new style contributions based on job seekers allowance. Oh, sorry, that's a statement, not a question. Sorry, I'm looking at the thing for a while. Someone said, I was moving into Universal Credit. I received a letter asking me to start the process. I'm worried about them stopping my money for a month. I'm really struggling with the cost of living in general. What support can I ask for to help me move more safely to Universal Credit? I'm worried about possible reductions. I have an additional bedroom. I have a son who's over 18, who sometimes stays. Can you please give me some advice? Well, that was a very long question, so I can repeat details if people need it. I don't know if that's something that, Mike, you're happy to sort of give a bit of response to.
Yeah, I think, unfortunately, it's one of those where I think the best thing you could do is give a more qualified welfare rights advisor a call and sort of work through it at a pace that suits you, because it is, like I said in my presentation, it is a very complicated area of the benefit system in general, and we know that when people are moved onto universal credit, because the system gets even more confusing, if you don't get the sort of right targeted support that could lead, and I don't want this to happen, and I think if you get the right support it shouldn't, but it can lead to you perhaps missing out on some of the stuff that you're entitled to even for a short period of time. Both Citizens Advice, but also Z2K, both provide like really good helplines for that. There are a couple of like more local advisors that if that person wants to grab my email and send it over, I can try and find some like very specific local advice, hopefully. But there are quite a lot of organizations that provide support in this area. I think that would be the best first step, rather than me, someone who's not a legal expert, giving non-legal advice at the end of a presentation where I probably bored everyone to death already. But that's sort of where I would start with that one.
Thank you. I will be sure we will send around a follow-up email to everyone, so I'll share. I've already just mentioned Mikey, as well as some others that people might find useful, as well as the videos that Rose referenced. So someone has said cheaper accommodation would likely be smaller. How does that work if you are a disabled wheelchair user?
Can you say that again? Sorry,
Sorry. Cheaper accommodation would likely be smaller. I think this is in reference to part of your presentation where you were talking about finding somewhere where your benefit claimants can more easily cover the rent. How does that work if you're a disabled wheelchair user? I suppose, is there any sort of allowances for disabled wheelchair users?
So that is where the sort of interaction with your local authority and the sort of discretionary element of what they can provide is important. But again, it's another one of those where like you are fighting to sort of maintain a system rather than the local authority being overly proactive with you in this instance. I think it's not actually something that I can think we have very, very recently dealt with. So I will go and check in with colleagues again. But you shouldn't, in theory, end up being punished for having more needs in that regard, right? But a local authority is making that decision based on, like I said, a lot of various factors, which also include the idea that if you might be able to find space like that is similar in a quite large geographic area, perhaps within the local authority, right? We know quite often that people are moved, not just like streets over, but like, towns over for that regard. And if the local authority feels comfortable that it can make the argument that, if you live in a city, that you'd be suited in the suburbs, that they might make that sort of decision. But again, it's one that you need sort of advice on and should try and push back on as and when you can. But it is an incredibly frustrating element of it, the idea that really what you're doing is fighting to maintain an allocation and maintain your home, rather than the local authority trying to work with you to sort of keep you there, if that makes sense. But that is immensely frustrating, and something that I'm very annoyed is the case for a lot of people.
I think we have time for just one more question. I'm aware there's more questions here than we've had time for, unfortunately, but I will, as I say, will share around some resources for people. So I do have that sort of at least provide a way for people to get the answers that you need. So finally, my 15-year-old son is a disabled wheelchair user, and they need adaptations like a shower rail. The landlord has refused to do anything, and this puts him in danger of falling, etc. What can I do? Do the local authority have a duty to help us with safer housing? Again, quite a lot.
You happy for me to come back on that one? I don't know if I don't think that we had time to mention this, but obviously if your accommodation is so unreasonable that it's so unsuitable for you that it's unreasonable for you to continue to occupy, then you may lawfully be considered homeless, and your local authority may have a duty to rehouse you. So once you've gone through all of the options that Mikey talked through about, trying to get adaptations to your home and asking your landlord and being refused, if you've got to the point where it's not tolerable for you to live in your accommodation, and doing everything you can to get the best evidence on that from your own GP, from local authority occupational therapy assessment team, to demonstrate that local friends, family, carers, school teachers, anyone can count. And I just want to make a point on that about evidence, that even if it can be really difficult to get people to put things in writing, but in terms of what is evidence, that the court can take into consideration, which a council should, a detailed note of a conversation. It also counts if you have a conversation with an occupational therapist or someone that is working with your child, and they allow you to take down a detailed note of the conversation. That can count as evidence as well, and you could potentially make a homeless application to your local authority.
Brilliant, thank you so much. So that is unfortunately all the time that we have for. Again, I appreciate there's more questions than we've had time to answer, but I will do my best to sort of get people signposted to places where you can find help. I'll just post quickly into the comments to reiterate, we can't offer specialised advice, but we do have some general information about rights. I have posted that into the comments section there. We do also value the experiences of renters and are always really keen to hear from people, especially people from marginalised communities and people who are disabled. So I'm going to send a link to our Share Our Story function on our website. So if you have an experience story that you'd like to share with us, be it sort of being a part of our campaigning or just sort of educating us and helping us sort of get a better gauge on what's going on with renters and disabled renters in particular, then that is a great way to go. Again, I will share all this around in a follow-up email, so don't worry if you can't sort of go there right now. And yeah, I just want to say absolutely thank you so much for our brilliant, fabulous speakers who've given up their time in order to do this, but absolutely did not have to do that. We will be receiving an email from us shortly with all links and resources available. Thank you so much for everyone who's joined today to hear from us. I really do hope that it was valuable, and I've certainly learned a great deal. So I really hope that you have as well. So yes, after only 1 minute over, so we're almost perfectly in time, which I think is pretty good for a webinar. Generally, they tend to go for a little bit. So thank you so much, everyone, for joining, and I will leave you all to have a great rest of your day.
Thanks so much, everybody. Appreciate it.
Thank you. Bye-bye.
Bye, everyone.